There we go. I get told off if I don't record them. If you are new to our seminars, then just to let you know that my specialist areas are, of course, in wills, trusts and probate. That spans both the contentious and the non-contentious side of things. Also property matters, and also property and affairs, court of protection matters, and we've also been running a number of seminars on those. We are at King's very friendly, as many of you know. Most of us operate a open door policy, and indeed many of you have been contacting me after seminars just to run a couple of things past me, which I'm always happy to do. So there are my contact details with my email address. We've also got a seminars email address, and so if you want to be added to any of the databases to make sure you get the invites, then get in touch there. And also if you ever want to provide any feedback or any suggestions for future topics, then get in touch on that email address. And also there is the email address of my clerk, Louise Barn, who will always be delighted to assist you with any queries. So as I say, a short update, and it's really just to run through what we think is going to be happening next month. Of course, we don't know for sure, but there has been some guidance produced by the government, which is on the website. It's relatively comprehensive, but it suggests that there is going to be an amendment to Section 9 of the Wills Act, which almost all of you will be familiar with. If you're not, then I've got a slide that sets that out for you. And it's anticipated that there will be a statutory instrument pursuant to Section 8 of the Electronic Communications Act, for those of you who like to know about statutes and statutory instruments. The anticipated purpose of this amendment is essentially to introduce retrospective validation of wills that were executed during the lockdown period and the public health crisis, where those wills were witnessed by video and the physical presence of the witnesses wasn't possible because of the lockdown. Now, this talk obviously comes with a health warning. The legislation, or the draft legislation, isn't yet available, so I haven't been able to look at that. Really, it's based on the guidance that's been produced, and I'm at the end of the talk just going to give a couple of thoughts of my own on how I think it might impact on us. So we don't know the full extent, and of course it may be that what's set out in the guidance may change. It may be more extensive, it may be less so. So I think that until you know the true extent of the changes, my own view is you would be well advised not to change any of your current processes. And I would be surprised if any of you were doing that anyway, in any event. Now, the reason for the temporary amendment is, as I say, because of the corona crisis. And this is the reason that's set out in the guidance online. And it essentially says that because of the lockdown, there are a number of individuals who were shielding and self-isolating. And so it became very difficult, as many of you know, for us as practitioners to go about the usual way of executing a will. And the problem that arose typically was that you had usually a vulnerable client or an elderly client who was shielding. Very often they were living with the person who is going to benefit from their estate. So of course they can't act as the witness, but because they were shielding, they were unable to leave their premises or their home. So it became difficult for the two witnesses to be in the physical presence of the testator to be put into effect. But certainly from discussions that I've had with many of my instructing solicitors and sort of evidence from on the ground, there were lots of ways that people came up with to get around that and still assist clients with executing valid wills. And so recognizing the difficulty that I think really lay clients will have had, so I don't think really these changes are actually aimed at the profession, to be quite honest with you, is that what the government are intending to do is to amend Section 9 to alter, I think the reality is the definition of presence of those making and witnessing wills, so that physical presence is now, it seems, going to include a virtual presence, and a virtual presence by a video link. So as I say, I anticipate that there will probably be some expanded definition of presence. And that got me thinking about, well, how is it actually going to be put into effect, and how wide is that definition going to be? Because if you look at section 9, which I've set out here for you, the word presence is actually used a number of times, and I've just summarized those on the next slide. So we have 3 instances where physical presence is required. And the first is that the individual signing the will at the testator's direction, if that's what's happening, must be in the testator's physical presence. So if we've got the will maker needing somebody else to sign on their behalf, maybe because of a particular infirmity or disability, that individual has to be in the physical presence of the testator. So that's the first issue. That the other circumstances are, as you well know, that when the testator signs the will, they must be in the physical presence of the 2 or more witnesses, and those witnesses who attest or sign the will must also be in the testator's physical presence. So that's the first requirement. And the second requirement is that when there are the signatures and the execution that's taking place, there must be what is described as the clear line of sight. So the witnesses must be able to actually see the testator sign the will and see the signature. So it's not good enough just being in the same room. That's not enough in itself. They have to be in the same room, maybe at a distance, but still be able to actually see that process taking place. And that got me thinking, well, what about section 9A? And that's about where we have a testator who, for whatever reason, needs somebody else to sign the will on their behalf. Now that's less common, but it certainly still happens. And it made me think, well, are these changes going to affect that? Because I can certainly see there is quite a big scope for abuse of that, because if presence in section 9A is going to be altered such that the individual signing on behalf of the testator can do that virtually, so they can be in Manchester, but then the testator is in Leicester and it's all being signed virtually. Well, for me, there's a huge scope for fraud and abuse there. So I do question whether the proposed amendment will go that far, or whether it's simply about the witnesses having their presence virtually rather than physically. And when I had a look at some of the examples in the guidance, I suspect, although of course I can't be sure, that it probably is just going to be limited to the witnesses rather than any individual signing on behalf of the testator. And I say that because of number 4 that they put down in the guidance. The guidance sets out these 4 examples about where witnessing virtually is going to be appropriate. And what is said is that where the testator is present with the person to sign on their behalf, and connected to the witnesses by a 2 or a 3-way video link. So it doesn't actually give an example within the guidance of the individual signing on behalf of the testator being in a different location. So I anticipate it's just going to be limited to witnesses, which I think if there is going to be some scope for innovation with wills, it really should only be limited to that because of the possibility of abuse. Now, this is the process that is set out within the guidance, and it's a 4-stage process, potentially 5-stage, depending on where the witnesses actually are. Now, it sets it out in this way, and everybody's got to check all these things with each other. They've got to check that everybody can see each other. So the idea is that perhaps they're using this kind of forum that we're currently using. So there has to be effectively a checklist. And if your firm is embarking or thinking about embarking upon changing its processes such that you can include virtual execution, then I anticipate that you'll want to be thinking about some form of checklist to ensure that you include everything that you need to, and also as part of your file that will provide some evidence to ensure that the Act is complied with. What the guidance says is that you've got to check that everyone can see each other. It doesn't actually mention about whether everybody can hear each other, which I thought was an interesting omission. I anticipate that's probably a mistake, because it seems logical to me and absolutely necessary that everybody needs to hear each other, especially if, because of a fixed camera, for example, somebody can't actually see the signature taking place. And so a witness may need to acknowledge this signature rather than actually the testator seeing it. So of course, there needs to be an ability to hear one another. The guidance says that it's not mandatory to record, but it's certainly suggested. And the reason it suggests that is it says specifically that, well, this may provide some evidence to a court at a later date in the event of a challenge, which is an interesting one, because it seeks to suggest that by virtue of it recording, that may give some cogent evidence, I think, that there is no undue influence or lack of capacity. And of course, that will go some way to assisting with that. But my own view is that a recording can't in itself be relied on to exclude those issues being present during any will attendance. So you're going to have to think about, in client care letters, who's going to keep that recording, how long it's going to be kept for, all those sorts of things, and what method by which it's going to be kept. So it throws up all these kind of issues that you'll need to think about contractually with clients, and also payment for storage of recordings and things. Then the guidance says what you're going to have to do is get the document, and you're going to have to hold up the front page to show everybody who is on the video call. So it says you've got to show the front page, and then you've just got to show the signature page. If I were ever doing this, not that I ever get involved in executing wills, but I would be showing every single page to make sure that everybody knows that there aren't any other pieces of paper being inserted. And you perhaps want to make sure that everything is initialed as well, to make sure it's all the same will. And then what you've got to do, and I think this is, for me, where it's going to be pretty tricky, you've got to ensure that obviously everybody can see the signing going on. And that's why I think it's difficult. If I look at my Mac now, it's got a fixed camera. And if I wanted to try and show you now me signing a document, you wouldn't be able to see that. And if I tried to move it down, you then wouldn't be able to see me either. So it does really throw up these practical problems, I think. And yesterday I was in a mediation, which, believe it or not, went on for 13 hours. I'm feeling slightly jaded today because it didn't finish until about midnight. But whilst we were waiting for this agreement to be drafted, my solicitor and I were discussing this, and we were sort of moving our cameras and laptops around to see how we could actually put it into practice. And it's really quite difficult if you're using a laptop or a Mac that has a fixed camera. And I think the reality is most people will be using those, because I don't know personally how you could then use a phone or an iPad to perhaps record something. I'm sure someone who's a bit more technologically advanced than me can think about that. But it may be that you maybe need two devices. So perhaps one that can capture the testator's sort of face and shoulders. And then perhaps if I had one over here, maybe on a tripod, which could also link into Zoom, it could contemporaneously, through the same live feed, capture me actually signing the document. So all these things have got to be considered. And then you move on to stage 2. So you've got to check with the witnesses. Now, I think the reality is that a professional is going to have to be one of the witnesses, or certainly have to be supervising the execution of this will via video link. But what they've got to do is they've got to confirm that they can see, hear, acknowledge, and understand their role in witnessing the signing. And this is where I say that some form of checklist to go through all these things, I think would assist individuals, particularly those who are, maybe trainee solicitors and just getting familiar with these kind of processes. It says ideally that the witnesses should be physically present together. And the reason that's ideal is because in stage 4, when you need to send the will on, if they are in different locations, you're going to have to send it to one witness and then to another witness. And that just makes the process even more protracted than it already is doing it with this forum. And then once you've confirmed all of that, the testator signs, and it's the testator that dates the will, not the witnesses. And apparently when they do that process, so they sign that will, then the testator should say this apparently at the time of doing it, that they wish to make a will of my own free will and sign it here before these witnesses who are witnessing me doing this remotely. And at the time that they do that, there needs to be, through the computer or the iPad or the phone, a clear line of sight of that signature. And in the guidance is suggested that if a testator says this, that this will go some way to perhaps assuring a court at a later date that there's no undue influence. I am personally not convinced that that will do that. Then once the testator is signed, we move on to stage 3. And this is where it becomes slightly trickier, because the whole premise of this amendment is that your 2 witnesses are not going to be with the testator, and they're going to be in a different location. So the will needs to be sent on to them, and it will need to be the document that the testator has signed. And this mimics some of the difficulties that I think some of you encountered with LPAs. And Paul Lakin and I did a talk a couple of months ago, right at the beginning of lockdown, about some of the problems that can arise with LPAs and wills during the lockdown. And with an LPA, you have to all sign the original document, but not necessarily all be in each other's presence. So there had to be this chain of sending the original document on through the post, with the risks that are inherent in that. And so this amendment may well throw up these difficulties. But what the guidance suggests is that ideally within 24 hours, the will should be sent on to the witnesses. And then once they receive that, then you've got to have another video conference. And again, you've got to go through that same process of holding up the will. So you've got to satisfy yourself that the will that those witnesses have is the one that the testator themselves signed. And the testator has got to, similarly to the first stage, have a clear sight of the witnesses, not just the heads and the shoulders. So you've got to figure out some way practically how you can ensure that line of sight. But what a witness can do is acknowledge their signature. So if that is not possible because of the makeup of the devices, then the witness can sign the will, then show it to the testator and say something to this effect, which is, this is my signature intended to give effect to my intention to make this will. And so there's an acknowledgement of the signature, which is acceptable under the Act. And of course, during the course of all that, it should be recorded a second time. Now, you may then have the difficulty of having your second witness in another location. And so you've then got to send it on again to that second witness, and again have another conference. So from a business perspective, I mean, many of you will be drafting these wills on fixed fees, but now you've potentially got to have a number of attendances, which I think certainly at the beginning, whilst everyone's getting familiar with this new legislation, if indeed you choose to adopt it, which I'm not convinced many of you will, to be honest, but if you do, you've got to, I think, have an initial attendance to go through all the aspects of capacity, all those kind of things, instructions. And then you've got to do stage 1 and 2. Then you've got to do stage 3/4 and potentially another stage 5. And that doesn't even take into account all those things that go on in between, if there's a change of instructions and all the advice that goes with it. So potentially it could be a more protracted and less efficient process than I think it currently is with just getting your client to come in and do it the old-fashioned way. So I'm not, I am all for video technology where it makes the justice system more efficient and it assists clients. But what I've come to realise is that there are certainly times where it's just simply not appropriate, and we should just stick to what we know best. And I do wonder whether this is one of those occasions. So that's the process, or the anticipated process. But what you need to just understand or flag up is its likely application. Now, as I say, we don't know the date of enforcement. It's likely to be September, and I have no doubt that when it comes out, that will be all over the legal press. But it is likely to apply to wills and codicils that were made between the 31st of January of this year, and the reason for that particular date was that was the first recorded case of coronavirus in England and Wales, I believe. So that's the date, and at the moment it's likely to remain enforced for 2 years, which is interesting, and it makes me well, it makes me slightly more pessimistic than I already am, because I was sort of hoping that life was going to start getting back to normal, to be honest. I've got my first attended trial next month after 5 months, so I'm really, really excited about that. So I was sort of hoping that life was steadily moving back to how we all knew it. But I suppose that this suggests that maybe the government think that there might be a second wave, because what this is aimed at is clearly those wills that were executed during the lockdown, but also in the future up until potentially 2022. And that struck me as interesting, because it's quite clear in the guidance that you should only be using video conferencing for the execution of wills as a last resort. And so it says that if you can do it in the conventional way, then do that. And that's the guidance that the OPG gave out about LPAs. Now, shielding ended at the end of last month. So it does make me think, is this being brought in anticipation of potentially a second wave and maybe another round of shielding? So it may well be that it does impact upon your practice, maybe in the winter months. So it's certainly important to keep an eye out for it. And we've got the sunset clause of the 31st of January, but that's subject to change. So it could be extended or it could be reduced. And it's important to keep an eye on it, because I think that, you know, there may be circumstances where some people get caught out. For example, you start the process by doing your stage 1, where your testator signs it, you send it on to your witnesses, witness goes on holiday, for example, so there's a delay of a month or something, and in that time the legislation ends. So you've got kind of partially executed will, and then what happened if the testator died? So it can really flag up some difficult questions and scenarios for us all. So that's why I sort of think maybe, you know, stick to the old-fashioned way. But one thing you do need to be aware of, as the guidance currently is drafted, is that it's not, even if the will is made after the 31st of January of this year, it's not going to apply to that estate if, when the legislation comes in, there is a grant of probate that's already been issued, or the application is made and is currently being processed by the registry. So that made me think of scenario where that might have some interesting outcomes. So I thought about this. Well, you might have John, who's made a will a number of years ago in 2006. He doesn't have a partner at the time, so he leaves his estate to his children. Then what he does is makes a new will after the lockdown in the February, where it's a homemade will, so no supervision by any professional, and he gets his neighbours to witness it using FaceTime. So as matters stand today, that will would be invalidly executed, but that would change potentially as long as there was compliance once the law changes. And in that will, the reason he changed it, because since 2006 he's got a partner, so he wants to give her a life interest in his property, with the remainder falling to the residue and going to his children. So after he has attempted to make that will, he passes away in the March, and it's a relatively simple estate, but the house needs to be sorted. So there is a grant of probate application in August, so before the legislation comes in, and then the legislation comes in the subsequent September. So you've got this sort of bizarre situation where if the grant hadn't have been applied for, the will would stand, but because the grant has been applied for, it doesn't. And to me, that would be a contentious probate claim, sort of waiting in the wings. So it will, I think, throw up some interesting cases for many of us. And my own view is that these changes are really, I think, aimed at the public who, in the mad dash to maybe alter their testamentary dispositions in light of lockdown, probably read something on Google and thought, yes, I can do it by video, because certainly from what I've heard from my own instructing solicitors, that no one, of course, really entertained witnessing things by video, and we all came up with innovative ways in which to circumvent the difficulties that shielding pose. Lots of examples of car bonnet execution of wills, doing it on the drive, even if somebody was shielding, or doing it through an open window. People came up with lots of ways that I think ensured that clients had properly executed wills. So I don't think this is really intended to affect the profession, but rather the public, who perhaps found themselves now with an invalid will, but perhaps don't wish to. But I think it will probably throw up a couple of issues. I mean, these are sort of my thoughts really on it. Technology could throw out some glitches. I mean, in my mediation yesterday, there were a couple of times where the screen froze for everybody. One of my opponents dropped out of the Zoom, which then had an hour's delay because he couldn't get back in. Sometimes it went fuzzy. Sometimes I couldn't hear my client just because of the microphone couldn't pick everything up. So there are all those difficulties to encounter, and I just wonder how, if you're removed from your client, how can you supervise those matters happening? Because if, for example, a witness is on the other end and it freezes for them, how do you know that they're going to tell you that? And it may well be that they just kind of ignore that or don't appreciate the significance of that actually happening. Because, of course, if it did freeze and you all acknowledge that, you could just restart the process again. But if somebody doesn't tell you that and it's only later picked up on a recording, then it potentially has a huge implication for that will. I also wonder about the particular platforms you can use, because if I'm using Zoom, for example, I can mute you all. And so there's no guarantee that everyone can hear everybody, that the recording is picking up everything it needs to. I think with Zoom, if it's recording, it will only pick up me speaking. And so, that could really be important for the validity of that will. So those are kind of things to think about. There's also, I think, an issue of confidentiality as well. You've got to send the draft or the partially executed will to the witnesses, and really those witnesses have got no right to have a look at that will. It's entirely a matter for the testator and the client, but you can't guarantee that someone's not going to be nosy and have a look. And so there are those issues, and I think some real thought needs to be given to how we protect ourselves against those types of issues. But for me, and maybe I think about this perhaps from a litigation pessimistic point, because I'm always the one cross-examining solicitors on when they have these attendances and there are issues of undue influence. And I know how difficult it can be to pick up on those nuances that are going on at the time. And it is very easy for me to come in a couple of years later and look at it objectively and say, well, with hindsight, did you realize that that was happening? And then you have this moment where the solicitor goes, oh God, now I know all this, or would never have done it. And, I've had some real sympathy for solicitors in those situations. Now, it's difficult enough when you're doing that in a room, conference room, you've got everybody there in front of you, because you can pick up on body language much better when somebody is there. You can pick up, which way somebody is looking, whether they're a bit agitated, what they're doing with their hands. And that's my real criticism of this push to use video conferencing in all aspects of law, because my mediation yesterday, it was a very hostile farming dispute. My client was with my solicitor, and it was very upsetting at times. And I felt very removed from her when she was getting upset. And ordinarily, I would, do my best to comfort her within the bounds of, that I'm able to. But I felt I wasn't able to do that. And I think that there are things that will not be picked up on video conferencing, particularly aspects of undue influence, because you have no idea and you cannot be certain who is in that room with that individual. You would have no idea if my husband sat here listening to this, not that he would ever be doing that, but you can't be certain of that. And sometimes you will have undue influencers who would just literally sit outside and listen, and the knowledge of the testator that that person is there can be enough to cause them to make a will that they wouldn't ordinarily make. And I think as a professional, you are not in control of the environment that you are when you have somebody there with you. Very often in conferences, if it has a particular feature to a case, I will insist on certain people sitting outside, because very often, you have some clients who their spouse or somebody else who wants to drive the litigation will speak over them. And so I will insist on them sitting outside if I feel I'm not able to speak to that person, take instructions properly. But you can't really do that. And it becomes very difficult. And also there's issues of assessing capacity. And I think this is particularly so because the reality is this legislation is intended to be aimed at people who are shielding. And that's usually going to be vulnerable individuals. And also there's the issue of the delay as well. Because of course, during that time when the will goes from the testator to the witnesses, the testator could pass away. They could change their mind. You could have someone say to them the next day, why have you done that? And it caused them to change their instructions because of undue influence. It could be that they lose capacity within that time. Then you've got issues of statutory wills, and you've got this situation where you've got, is the partially executed will a relevant written instrument for the purposes of a statutory will application? So it can throw up a number of problems. So I think overall, my own view is that I would personally stick with doing it the old-fashioned way. And I certainly wouldn't advocate making any changes to your day-to-day practice until the legislation is available. And certainly at that point, I have no doubt that in Chambers, we will be holding another seminar with perhaps a bit more clarity and a bit more guidance on how you might move forward if you do wish to incorporate that into your practice. So I hope that was to some degree useful. And of course, if you ever have any questions, then feel free to email me at fcollinson@kingschambers.com. And I hope that you will have a lovely afternoon and a lovely weekend. Apparently it's going to be very nice weather, certainly in Manchester. So thank you very much for joining me.